A couple of sort of clarifying statements and caveats first. When I talk about international law, I mean the body of laws that states have either explicitly agreed upon by means of concluding treaties, or the body of law that arises from the continuous practice of states. So, law that operates on the international level. The other sort of introductory remarks I should make is that my own research has really focused on the use of pharmacological agents for performance enhancement in the armed forces and the legal implications of that. But some of the findings, I suppose, of that work can be translated across to implants, because sometimes implants are used to achieve the same effects as pharmacological agents, and potentially you can also have implantable devices that dispense pharmacological agents into the body. I have, however, done some work for the Defense Science and Technology Group in relation to implantable and wearable devices. So I must say at this juncture that while I'm eternally grateful to the DSTG for their kind support, nothing that I say should be construed as representing the position of the Australian government. I'm also a lawyer rather than a biomedical engineer or a medical doctor, so that sort of gives me a particular perspective, I suppose. And I should also perhaps note my bias of sorts. So I don't come here as a lawyer who is advocating for a particular program of further regulation. I don't think that the military is evil. I don't think that implants are bad and should be banned. I don't think that human enhancement is some sort of a horrible moral wrong. So I don't have any of those particular agendas to pursue here. What I'm really interested in is that if we do use certain biomedical interventions, such as implants in the armed forces, what are the legal constraints that apply, and what are the potential legal consequences that follow from the use of these devices. So I want to talk about two issues. One is the right to bodily integrity of the soldier. So it's a human rights issue relating to the soldier who is being implanted with something. And the second issue that I want to talk about is the protection of military medical personnel under the law of armed conflict, and what kind of an impact does human enhancement and the use of implants for enhancement purposes have on the protection of those professionals. And perhaps the key point which will come out of both of these discussions is that the legal issues will very much depend on what type of an implant is being used and what the purpose of that implant is. So there's no common legal framework that will apply to all kinds of implants in the military context, but rather we need to focus on what those implants do. So before I talk a little bit about the human rights of soldiers, I should perhaps clarify that soldiers indeed do have human rights. This is something that is not necessarily always at the forefront of the minds of people who talk about human rights law in the military context. It's difficult to think of people who come in contact with the armed forces as those having rights, and the soldiers as those who violate those rights. Especially I found that when I talk to human rights lawyers from Latin America, they just completely blank out if I mention human rights of soldiers. It's just not something that they think about. Soldiers are the bad guys who torture people, etc., etc. But my basic point is that soldiers have rights under international and domestic law. The human rights instrument most relevant to Australia is the International Covenant on Civil and Political Rights, one of the more widely ratified human rights treaties in the world. But I put this quote up here from the European Court of Human Rights. So the European Court has said in relation to the European Convention on Human Rights that soldiers are the beneficiaries of the European Convention on Human Rights, but the court, when applying the convention, will take into account particular characteristics of military life. And I'll come back in a minute to how that is being done. So, the human rights issue for soldiers is their right to bodily integrity. It's a difficult right in the sense that there's no specific treaty-based right to bodily integrity within the context of the International Covenant of Civil and Political Rights. Rather, the right to bodily integrity arises out of two treaty-based rights: the prohibition of torture, inhuman and cruel treatment on the one hand, and the right to privacy on the other hand. So I'll put the provisions up here. So Article 7 of the Covenant, or ICCPR as lawyers like to call it, says that no one shall be subject to torture, inhuman, degrading treatment or punishment, and in particular, no one shall be subjected without his free consent to medical or scientific experimentation. And while in the legal systems of many states it is accepted that soldiers are obliged to accept standard medical treatment, it is not the case that they may be subjected to experimental medical treatment without their will. So in the case of the US Armed Forces, that has a reasonably clear rule around the requirement of informed consent not applying to soldiers, still would require informed consent when it came to off-label use of certain drugs. So the problem here is that what is the implant the hypothetical implant we're discussing for? Is it meant as some form of medical treatment, or is it meant for some non-therapeutic purpose? And particularly in circumstances where no particular benefit, no particular health or medical benefit arises for the individual combatant from the use of the implant, we are really getting into the territory of medical and scientific experimentation. So hence, the implantation can only take place with the consent of the soldier. However, what about circumstances where we don't get to that level? So where we accept that, well, the use of the implant is actually part of some form of medical treatment. Does that require the consent of the individual service member? And this makes me unpopular among my human rights lawyers friends, I don't think that consent for medical treatment in the armed forces is always necessary as a matter of international law. States may provide that individual consent is always necessary, but they're not compelled to do so under international law. So until April last year, if I'm not mistaken, there was a regulation in place in Australia that actually required soldiers to accept medical treatment that was deemed necessary by a medical officer of the Australian Defence Force. That provision has not been used for decades, and in any event, that provision ceased to have effect in last year. So what does international law require? International law requires that no one shall be arbitrarily or unnecessarily subjected to interferences in their private life. And private life, as various international courts have made quite clear, includes matters to do with the person's body. So the right to privacy guarantees that no non-consensual medical interventions should take place. But I draw your attention to the word arbitrary, which means that if an interference with private life is not arbitrary, it can take place without the consent of the person. And human rights courts have developed a fairly complex framework for assessing when an interference with someone's private life for medical or other purposes is or isn't arbitrary. I'll just quickly summarize that. There are three requirements in order for an interference in private life not to be arbitrary. The interference must be based on law, the interference must have a legitimate aim, and the interference must be proportionate or reasonable. So, if we enact clear legislation, which on the basis of national security or public health concerns requires soldiers to accept certain biomedical interventions, then often the matter comes down to the question of whether that requirement is proportionate to the aim that is being pursued. And there's a a wealth of case law around what constitutes proportionality in this context, but some of the things that human rights courts have considered, for instance, is whether there is an option for a less invasive intervention. So in the context of implantables, that raises the question that could, for example, a wearable device provide the same military advantage, the same benefit for national security purposes. There's a question about the relative harmlessness of the intervention. So the more harmful potentially or more risky the intervention, the less likely it is that a compulsory intervention would be disproportionate in light of the public health or national security aims. And finally, there are questions about whether the intervention is being carried out in a medically ethical manner. So the bottom line here is that, again, there's no general rule that will apply across to all implantable devices. The question is, what are they being used for? What is the health or security aim that is being pursued? And whether the use of implantables in that context would be proportionate to that particular aim. I will not go into the rather problematic issue of whether consent can ever be fully informed and voluntary in the context of the armed forces. There's plenty of literature about that. But I think the bottom line is that if we assume that a soldier can never voluntarily consent to anything because of the framework of the armed forces, then it's basically impossible to provide ethical healthcare to soldiers, and I don't think this is really what we think. All right, so I'll move on to the second issue that I promised to mention, and I'll do this fairly briefly. One of the best established rules of the law of armed conflict, or the law of war, or international humanitarian law, however you want to call it, is that medical personnel of the armed forces must be respected and protected in all circumstances. That means that the medical personnel belonging to the armed forces or party to a conflict cannot be attacked, their activities cannot be interfered with, they cannot be detained other than to a degree that is necessary for the provision of medical care to prisoners of war, and so on and so forth. So a number of things follow from this respected and protected in all circumstances formula. But I draw your attention to the fact that this protection extends to medical personnel who are exclusively engaged in, and then there are various references to medical logistics, but in the treatment of the wounded or sick or the prevention of disease. So the fact that you're a medical doctor working for the armed forces does not in itself entitle you to special protection. It's the fact that you are looking after the wounded and sick, providing them treatment, and perhaps engaging in efforts to prevent the spread of disease. Jai conveniently already touched upon the issue of how do we distinguish enhancement from treatment, and again, a lot of bioethical literature on that. The distinction actually is trickier than it first seems, because it also has to do with the question of what is a disease or malady that is being treated. And it seems that the definition of disease in the abstract has been fairly difficult for philosophers of medicine and bioethicists. In most domestic law contexts, we can solve this problem by resorting to some sort of a list of things that are considered treatments. So, for example, when the question arises whether some biomedical intervention is a treatment or enhancement for, say, Medicare purposes or for our private insurance purposes, there's usually somewhere a list of procedures that are considered to be treatment. And if something isn't on that list, then it would be deemed elective, or it would be deemed enhancement and not covered. However, here we're stuck with the word treatment, and we don't really know what precisely that means. There's very little by way of state practice to actually interpret this term, because most of the times this provision is seen as clear and obvious in its meaning. What I also draw your attention to is another provision in the Geneva Conventions, which deals with a situation where medical units lose their special protection. So like medical personnel, medical units are also entitled to special protection. but they lose that protection when they commit, outside their humanitarian duties, acts harmful to the enemy. And the general understanding is that this test also applies to medical personnel. So medical personnel, even if they normally engage in activities that are treatment or disease prevention, once they commit acts outside their humanitarian duties that are harmful to the enemy, they lose their protection. I would argue that if we're talking about implants that are meant to treat a particular condition or help manage a particular condition, so for example, an implanted pacemaker, then that isn't really particularly problematic. It squarely falls within the humanitarian duties of medical personnel and falls under the notion of treatment. However, if an implant is placed inside a person or drugs are provided to that person in order to enhance their military performance rather than treat a malady, then I would argue that this could constitute acts harmful to the enemy. It's actually assisting soldiers to perform better at what they do, which is killing people and breaking things. So a medical professional who engages in human enhancement activities, whether it is through implants, wearable devices, medication, or what have you, can actually lose their protection under the law of armed conflict. I will stop here, and I will again come back to the first point that I made, which was that it's difficult to look at implants in the military sector holistically, but rather it will often come down to the question of what type of implant is and what it is being used for, who is doing the implanting, and so on and so forth. So it's a very context-dependent analysis. Thank you.
Thank you so much.